Hello. For the past 7.5 years, I've been quite reluctant to make any live broadcast, but under the circumstances, I feel that I have no other option. As Medway Council continue to persecute and destroy my younger son and daughter, I would very much appreciate it if you could take the time to please listen to my response to these current proceedings, which are an injunction, an interim injunction, an undertaking, and a draft non-molestation order. And I've addressed it to HHJ Richard Polden. Firstly, I would suggest that you are in a somewhat difficult position, as the social services for the past 7.5 years have stated that I have been suffering for more than 20 years from an extremely life-debilitating condition, that being the infamous narcissistic, histrionic, borderline personality disorder, rendering me emotionally unstable. In fact, for the past 7.5 years, this has been relied upon time and time again. So, does Richard Polden, I put to you that if I am mentally ill, attention-seeking, and a drama queen, which by law makes a person deemed to be not legally culpable to stand accused of alleged contempt of court, especially when they are unrepresented, as I currently am. Or perhaps I am not giving you any other option other than to admit that the Medway Social Services case for the past 7.5 years has been based upon a lie. I quote the Right Honourable Ted Baker, who calls me his friend. This case has been one perpetual lie. Shall I quote his friend, the Member of Parliament, Mr. Mark Reckless? Tell Sara to name and shame each and every one of you. And whilst we are on the subject, how about the initial emergency police protection? What was it? Both children were described as extremely thin, a global delay, there being clear signs of neglect, which brings me on nicely to the fact that Detective Constable Mark Noble later admitted to me that he only granted the lying Detective Constable Alexander Smith her emergency police protection on the basis of her description of my children, that being they were extremely thin and clear signs of neglect. They were immediately taken to the Medway Maritime Hospital, where they were described as of average height and weight, clean and tidy, and well behaved, and subsequently discharged. He didn't realise that until hours later, because they were taken on a Friday afternoon and he went home to be with his own family, while my family were being destroyed. Secondly, I would invite you to fully read my published account on Facebook of the Medway Social Services involvement with my family over the past 7.5 years, if you haven't taken the opportunity to do so already, as you yourself are quoted in it from back in 2012, where you addressed the senior social worker, Miss Kelly Ann Hopper, and you said, in my judgmental view, Ms. Root should apply to discharge Damien and Chanel's care orders, and you duly advised me to apply to the Court of Appeal, which on that occasion was heard by his Lord Justice Mumby, where he alarmingly highlighted, amongst other things, the fact that Medway Council had terminated my direct contact without having the legal authority to do so. That, as you are fully aware, is a Section 34.4 of the Children's Act 1989. You, I believe, are also fully aware that the original care orders were obtained by deception via your colleague, District Judge Graham Green, who, I quote, "I'm not granting you full care orders, so the budget doesn't allow for it." Then, however, he said he will only grant full care orders in the event that he is assured of future contact. Hence the contact agreement signed by the lying Mr. Ian Charles Scrivens, when he knew my direct contact had been illegally terminated with Damien 14 months previously. Chanel slightly longer. The Section 34.4 wasn't granted for approximately 4.5 years. So if I am mentally unstable, that I couldn't possibly be in a position to be able to publicly prove my case has been an illegal witch hunt, could I possibly have in my possession the appropriate evidence to prove it? Or do I lack the mental capacity to realise that if you continue on this path of being a corrupt judge that I know that you are, that yes, you do indeed have the power to send me to prison, an innocent woman to prison for an alleged offence under the Children's Act 1989, Administration of Justice Act 1960, Reporting Restrictions Order. But we both know that the Children's Act and the past care proceedings for Damien and Chanel are adults. Let me now come to your original injunction under the Administration of Justice Act 1960. Any case must have ceased to have any effect as on Damien's 18th birthday, notwithstanding the fact that the preceding judge described your injunction as deficient, not clear as to what I couldn't do. In other words, it was unfit for purpose. It having been buried in 2014, to permit me to publish my case in order to pursue a complaint. Specifically, I quote, the Family Court Media Access and Reporting, July 2011, paragraph 11, Practice Direction 12.73, proceedings relating to children. This rule permits the communication of information about the private proceedings to specified persons, but prohibits the communication of information about the Children's Act 1989 proceedings to the public in general. Paragraph 40, Rule 12.73 does not permit the disclosure of documents or information to members of the media, and to do so remains contempt. However, a party may, because of Rule 12.75, which I have legally had since 2014, makes me be able to make disclosures to a journalist, if necessary, to enable a party to make a complaint against a person or body concerning the proceedings, which is exactly what I have done. Or regarding the law, a journalist who receives such documents is, however, forbidden from putting the information into the public domain without the permission of the court, which proves I am not in contempt of court, proved by the fact that my Facebook campaign commenced in August 2014, 4 months after I had legal permission to do so. Still waited years, even after you destroyed my family. I still waited, I still abided by your injunction for years. The barrister, Edward Elliott, states that this is a lie because my Facebook campaign fails to prove I did this for the purposes of making a complaint, because I have failed to exhaust all other avenues. However, this is a brazen lie, because I have been to the council's complaint manager, Lynn Bush, the customer relations investigations officer for social care in 2014. She seems to have forgotten to initiate a response. The government ombudsman, the children's commissioner, the information commissioner, Rodney Chambers, council leader, Councillor Ted Baker, the MP Mark Reckless, the Essex MP Jackie Doyle Price. I have begged to see the former Director of Children's Services, Rose Collinson, Lord Justice Mumby, Justice McFarlane, the then legal officer, Deborah Upton, who accidentally sent a note to Councillor Ted Baker, confirming that the council hadn't complied with the court directions. She was asking the court to dismiss my case. How dare he state I haven't exhausted all other avenues, and my Facebook campaign does not equate to the use of my legal power under the Practice Direction 12.73, when no use destroyed my family for 7.5 years. Not only that, but I can confirm that I sought clarification via my Mackenzie friend with legal knowledge, Ms. Christina Ellis, who in turn sought clarification from her college tutors, who confirmed, following the variation of your injunction in 2014, I have the legal right to publicise my past care proceedings in order to make a complaint against the local authority for destroying my family, and to highlight the deficiency in the law. Therefore, at that point, your injunction denying me the right should have been automatically discharged. I was informed at the last hearing that I had been in breach of Section 12, and I quote from that approved judgment by Jane Mumby, A Child, 2013, paragraph 21. what may be called automatic restraint on the publication of information relating to proceedings under the Children's Act 1989 are found in Section 97, and that Act, Section 12 of the Administration of Justice Act 1960. Section 97 prohibits the publication of material which is intended or likely to identify the child. This prohibition comes to an end once the proceedings have been concluded. Your injunction was sanctioned post the conclusions of my care proceedings. Section 12 does not protect the identity of anyone involved in the proceedings, not even the child. I have done nothing wrong, and I have every right to expose you for what you've done to my family, and you will not gag me indefinitely or destroy my family any further. I therefore confirm that I wish to cross-examine the social worker, Miss Kelly Ann Hopper, the Director of Children's Services, Anne Dominey, who is predominantly responsible for my case. I carefully note she is Director of Anne Dominey Children's Services, currently in liquidation. As I do Sarah Jane Scarratt, wife of His Honour Judge Richard Scarratt, being the trustee and company director of 3 children's homes, which I find very concerning. I also wish to cross-examine the lying B, who has claimed to the court that I was served personally with this committal application when I had gone out for the evening. So if this application isn't immediately dismissed, I will ask my supporters / witnesses here today to make public that I was subject to illegal proceedings. As Miss Kelly Ann Hopper states in her affidavit, Ms. Sara Jane Root is no longer subject to either the Administration of Justice Act, the Children's Act 1989, or the Reporting Restrictions Order. Therefore, your original injunction taken out against me in 2011 to gag me is no longer in effect, as is the new interim injunction granted by Her Honour Judge Lazarus, being that of Section 97(2) of the Children's Act 1989, which at the last hearing the barrister, Edward Elliott, confessed to his mistake in not extending it because it had lapsed, which is why he panicked and came up with an undertaking. The said undertaking is no different to 2 deceased injunctions. I have not breached the original injunction. I will not be gagged, or indeed the subsequent interim injunction. So I cannot possibly have breached an undertaking that allegedly replaced them both. Unfortunately, I have very little recollection of that hearing, as unfortunately I had stayed with my older daughter the night before the hearing, and I had forgotten to take my medication due to the fact I'd had thyroid cancer. So sadly, I wasn't able to mentally function as I should have. I am not mentally ill. I am not a paedophile, child abuser. I did not neglect my son Damien and Chanel for 12 years. And when I returned to the police station on the 24th, after 11 months of being charged with sexual abuse and being put on bail, if I am not de-arrested with no further action, I will instruct my solicitor to initiate criminal proceedings against the Medway Police. I have indeed been declared not a paedophile with no further action, as sadly it was a very sad fantasy made by my daughter because she's been so damaged by the local authority. My daughter, however, certainly has been sexually abused by the foster carer's son at the age of 15. She is disabled, autistic, and now seriously mentally ill. She is now so damaged that my family have decided to disown her. They can't cope with her lies or behaviour. My daughters describe her as a very disturbed young lady and have advised me to stay away from her. I will never do that. There will never be an order to make me forget my family, my younger 2 children. There is no order or amount of threats that will stop me from telling the world what Medway Council have done to me. And all they wish to do is hide behind the corrupt judge, Richard Polden, who stamps every single order. I very much thank you for listening. If anyone is able to attend my hearing tomorrow, I would be extremely grateful, and I will post more information before and after my hearing. And as always, everyone who's taken an interest in my case has my eternal gratitude. Thank you. I can't do it.